What is the order of creditors when you're going through a liquidation? Hi, I'm Kimberly Shackrock, qualified chartered accountant, property investor and entrepreneur. Let's sit down and have a chat. What is the order of creditors in a liquidation? So under law, there is a specific way that liquidators or administrators of a company need to look at resolving things within a company when there are issues. Whether this be a solvent position, whether this be an insolvent position, there are specific ways to deal with it. In an insolvent position where the balance sheet is negative, it becomes very, very clear how it is dealt with. So who are the people that are not going to get their money back? So let's have a look at that order. Let's have a look at how it fits together, and then we can just get an understanding of this area. Should anything be dealt with, and it may even be that nothing's going to happen, but it makes you aware so you know what you need to be doing to ensure you're not going to be bottom of the rung of people that get their money back. And maybe it will determine what you need to make sure you're doing if you're investing with someone else, or whether someone's investing with you, to make sure that they're going to be treated in a better position than would otherwise have been treated should something unfortunate happen to your business. The first point that we probably need to raise is the secured or unsecured creditor position and what it really means. For a secured creditor, we have a definition which is directly tied to an asset or investment that holds security or lien against a debtor's property. The lien is often agreed upon at the time of the debt being taken out and is most often held as collateral in the asset purchase. So in this case, we're thinking a property, a mortgage, they're usually secured on the property. So if anything happens, when that property is sold, they will get their money back. So this is where we're talking about a secured creditor. We're talking about first charges, second charges, those sorts of things on specific assets. An unsecured creditor have outstanding loans with the debtor, however their agreements do not entitle them to a lien or a right to claim the assets or of the debtor. Unsecured creditors tend to include things like credit cards companies as well as other cash in advance companies. So this tends to be anybody else that is owed money, whether it be private investors, whether it directors' loan. It's all these that have no security against the money that has been provided into the company. The next question we need to consider is the question of timing of the secured status. When did it actually become secured? A lien is a legal right placed on an asset which is often used as collateral to secure debt. Now, there are problems that could arise when a single asset is used as collateral to secure more than one line of credit. So this tends to mean that more than one lender could potentially own a secured claim against a single asset. So this is where you've got your first charge, second charge. There's more than one person who is claiming against a single asset, and the question then comes, is that asset enough value to cover the other loans that are available? Because obviously if you've got 100,000, you've got secured debtors 150,000, they're not all going to get their money from that 100,000 because there's too much owed against that compared to what the value of the asset is. So this general rule is that the first creditor to secure a lien receives priority, which is where you kind of get the first charges, the second charges. It's the person that's put it in place first rather than any others, or the person that's got the highest priority. Within law, there is also something called a preferred status. So the preferred status is an individual associated with the debtor who is given some priority during the liquidation process. These creditors may not have held rights to claim assets, but they are given preferential treatment during any liquidation or close down processes. So this may be considered to be a special type of unsecured creditor, and this may be things like company employees, tax agencies, environmental claims, tort victims. It's people that are coming through courts or government agencies or individuals within the company like your employees, as we've said. So what is the order of creditors in a liquidation process? So as you can see on screen, we've got liquidator fees and expenses because they do the work, they're going to get paid first. We then have our secured creditors with fixed charges. So these are the people that are owed money and have a specific charge on it. So let's think of, for example, mortgages. You have a mortgage, they have a first charge on the property. Secondly, we've got our preferential creditors, which are the ones we mentioned a moment ago. So these are the ones that are like your employees, your tax affairs, things like this that will need to be paid. We then move down onto our secure creditors with a floating charge. And what a floating charge is a charge over a range of assets. It's not specifically like a mortgage is specifically on the property that you purchase. It may be you've got a general business loan and it's over the assets of the business. It's not specifically over a asset, it's over all of the assets. So therefore any equity you have in those properties that hasn't been used to pay the preferential creditors, that is where this money will then go to those with a floating charge. After this, we go to our unsecured creditors, which are not connected. We then go to our connected unsecured creditors and then to the shareholders. So the difference between our connected and our unconnected, the creditor group that is the connected could include things like a director's family member or an employee who has loaned money to the business. Employees' expenses also fall into that category. So they're all connected with the business. They come after the unsecured creditors, which may be just your normal suppliers, contractors, and other bits. There is a lot of specifics that go into a lot of different areas that go in a specific order. So depending what you're looking at putting into a company, you may need to have a look at how things fit together. Ultimately then, the final people who will get any money back is the shareholders if there is anything left to receive. Obviously, if everyone can get paid, then it keeps it simple. If there is not everyone that can be paid, then it starts at the top and we start with the creditors that are secured, they get paid in full. We go to the preferential ones, they'll get paid in full. When we then get down to the further down ones, which are our secured creditors, this is where then we start paying all of them if we can. If we can't pay all of them, they will all get a proportion of the amount that they are due back. And then it will move down to the next ones who, again, if the previous line is paid in full, it will be a proportion of what is owed to them. And the shareholders will ultimately get something if there is anything left. And that is the only point. So in a compulsory liquidation where it's insolvent and something's happened to the company, then it may be that the shareholders don't get anything. In a voluntary liquidation, the expectation would be that the shareholders would be getting something, having satisfied all of the different people above. So potentially, if you are closing down the company under a voluntary liquidation, you'll have paid off, sold the property, paid off the mortgage, you'll have potentially paid off your investors. So the only people left that are owed any money is potentially your directors, loan and your shareholders. If, however, you've still got all the different people to pay, then all of those will need to be paid before you as the business owner will be paid. It should be noted as liquidators get involved, if you have, for example, paid off all your director's loan, but you've not paid off other people first, they have got the right to request that money to be repaid to ensure that the appropriate people are paid in the appropriate order. So you will have to clear each line of persons before you can move to the next line. So that means if you are doing anything untoward as you head towards liquidation, whether you're closing it down voluntarily or compulsory, then there is specific ways to do this, and if you don't do it in the right way, you can be charged with wrongful trading or unlawful trading. So if you're in an insolvent position, you just need to be careful to do things in the right way. If it's just a voluntary one, then it's just a matter of making sure that there are funds to cover any other different costs. As directors of the companies, you have specific responsibilities, and if you don't fulfill those, then a liquidator can come to you to request different information, request different monies, and be looking at you to see whether you have behaved in a responsible way as a director. If you find that you are in that insolvent position and things are not looking good, we tend to suggest that you speak to an insolvency practitioner to just ensure that you're not going to do anything to get yourself in trouble. If you are looking at closing down the company in the right way, because you have to go through a liquidation process, then again, you can still speak to a liquidator to ensure that as you're doing things, before you get them involved, you're doing things in the right way, before you're ready to engage with an appropriate liquidator to help just close things down with the appropriate paperwork, where your balance sheet reserves are over the 25,000 and you'll have to go through a formal liquidation to close the company. The key aspect here is you just need to ensure that you are sufficiently educated in this area. If you are working down a liquidation route, whether it be compulsory or voluntarily is a little easier because you know you're going to end up with the final figures at the end. So as long as everyone else is paid, you're relatively safe. Whereas if you are not going to be able to pay everyone back, then you do just need to make sure you take care, because there are certain orders that things will need to be done, and if they're not done in that order, then you can get in trouble. And obviously for all of this, we don't want anybody getting in trouble. We want things to be done in the right way. Hopefully today you've discovered all about what the order is when you're going through the liquidation process. This process will be needed when you are closing down your company. If you have any questions, then please do leave a comment. Please like the video and do subscribe to the channel. And let's make tax less taxing.